Thank you to XKDR and everyone for having us over for this book discussion. Uh, so for this book talk, I'm just going to cover one issue on judicial statistics because I have a feeling that's something that most of the XKDR folks can relate to. And then Chitrakshi will talk about one of the core arguments in our book, which is on decisional independence of judges and how we assume that it's affecting the ability of the district courts to dispose cases. Okay. So just a little bit on why we wanted to write this book in the first place. As you know, most of the conversation on judicial reforms in India is hijacked by the fact that that the narrative is that there is a shortage of resources in terms of both judges and finances, and this is a narrative that has been set to a large extent by the Supreme Court itself since 1990, when the first All India judges PILs started to be heard by the Supreme Court. And we just wanted to look at the issue from a different perspective, which is transparency and accountability. That is, how transparent is the judiciary to the general public, and how accountable it is, and how accountability mechanisms can also impede the swift disposal of cases. So to that extent, this I already covered. So let me start. So let me start on the judicial statistics first, right? So these are the figures that we've taken from the National Judicial Data Grid. They give a cumulative figure on pending civil and criminal cases, and as you can see, it comes out to about 4.5 crores. 4.5 crores, yeah. Sorry, 45 crores. No, sorry, 4.5 crores. Sorry, my bad. So 4.5 crores. And this is the figure that then gets bandied about in all the reporting and, the narrative building around the problem of what exactly is the problem with the Indian judiciary. But I think, as a lot of us who have already worked on judicial reforms have known for some time, these figures are not very accurate, in the sense there are a lot of problems with how data is inputted, etc., etc. But we also wanted to cover the issue specifically on, the design issues itself. And it's important to start off. So this disclaimer used to be there on the old National Judicial Data Grid. It was replaced in last August when the Chief Justice was exiting office. He was doing a lot of house painting, so to say. And you've got this disclaimer here where basically the NJDG, the E-Codes Committee, is saying we cannot verify, like, none of the information out on this website, we are vouching for its authenticity. And this is after spending 2,500 crores on the E-Codes program, and judicial statistics being one of the chief objectives in the first vision plan of the E-Codes. This was supposed to be one of the major problems that they were supposed to tackle. So the only thing that changed last year is the disclaimer became smaller. Actually, what I've reproduced here is only one paragraph. The old disclaimer was an entire page long. This disclaimer is much smaller, but they're basically saying the same thing, that we are not vouching for any of the data on our website, which is an odd claim to make after you've spent so much money. And also, mind you, this is one of those few cases where the courts had complete control. They have been crying and screaming for financial autonomy for a long time. They finally got it with the E-Codes project, where the DOJ has basically given them a blank check, and all design decisions are taken by the Supreme Court. So they can't even blame anybody for getting this wrong. So let's just come to the issue of overcounting cases. So one of the problems that we noticed, we've not gone into this in too much detail in the book, but I thought this would be an audience that would be interested in this, is when it comes to cognizable criminal offenses. That is, when cases start at the police station through an FIR, and then there is an arrest and the case then moves to the courts. They have, for some reason, have not developed like a unique docketing number to capture all FIRs, to capture all cases coming out from one single FIR. So as a result, you have scenarios like this. So this is a case where you can see, this is from Patiala House Court. The FIR number is the same, but you can see two different cases registered. They also have two different CNR numbers, which is the unique identifier used by the e-courts to count cases. So this was a Section 498A case. That's cruelty towards wife, which was filed against the husband, and was a bail, and then there was a settlement. So you can see one case resulting in one FIR resulting in 2 cases in the court system. And then it gets worse. This is a case where this is the Directorate General for GST Intelligence, which is in charge of enforcing the GST law. And they have gone about arresting people liberally, because unlike the income tax department, they don't need the court to take cognizance of a offense. The GST officers can go and arrest people directly. So this is again a case against a husband and a wife who were running a corporation. There was some ghapla they were doing on input credit tax or something like that. So these are all 4 bail applications are pertaining to the same offense. I think the first time they were rejected, and the second time they finally got the bail. And there are 2 more. This was a modification application wherein they just wanted the conditions of the bail relaxed to go abroad. So you have one case, one criminal prosecution, basically being counted as 6 different cases in the e-court system. And given the number of cognizable offenses that are there in the criminal justice system, where the police are filing FIRs, arresting people, and starting proceedings, the overcounting that must be happening is significant. Neither Chitrakshi and me have the skills to estimate how much it is, but I'm sure some people in this room can do that. And it will be great if we could get a number on the extent to which these cases are being overcounted, because we'll finally know the extent of the problem, because I'm quite sure it's not going to be 4.5 crore pending cases. The number is going to be significantly less. And I'm guessing even technically, this is such an easy problem to solve. If you have just have a docketing practice where every, prosecution FIR is logged as under the same number. Right? Sorry, this is... Yeah, so this is another problem. So this is not an NJDG problem specifically. This is about prosecutorial practices by some government agencies. So this is a case where a businessman was caught in Kerala for not filing his income tax returns for 7 years, the substantial amount of 1 crore or something. So the income tax department prosecuted him for 2 offenses, for not filing tax returns and for not disclosing income. And they ended up filing 14 criminal complaints, 1 criminal complaint per year per charge. And I'm not sure why they did this, but I can presume that, billing practices of government lawyers is usually, it's pegged against, the number of cases that you have filed. And judges also love it because, so this was a case where all 14 criminal complaints were heard together. The judge gave 7 judgments. So he clubbed 2 criminal complaints per year into 1 judgment. And he gave 7 judgments. So for when his performance assessment happens, the unit system, the way it logs cases, Chitrakshi will talk about that, he gets to show that I've disposed, 14 criminal complaints. So he's happy, the government lawyer is happy. Now, what happens in appeal? So the conviction was by a judicial magistrate. So he has to file an appeal before the sessions judge. Now he has to file 14 appeals because there are 14 different criminal complaints involved. Plus, he has to file 14 stay applications on the sentence because he was found guilty, convicted, sentenced to jail for 3 months. So he has to get a stay even on that. So you've got this entire case which is building up into, it's the one prosecution builds up into 42 cases. And I can bet you the trial in this case would not have taken more than a day, because he did not file income tax returns. There must have been 2 or 3 witnesses. So it had been disposed quite swiftly. But that number is not reflected here, and you're not capturing time that is being spent by the judge when they're disposing all these cases. So these were some of the complaints that we had on how, judicial statistics are being counted. And I think, some interesting research questions would be on just how do we try and fix this problem tomorrow if there is an opportunity? How do we develop, what should we be measuring? I think all of us will agree that should be time more than anything else. How much of the judge's time is being spent on what activity? And then we need to have better typologies and classification for cases, So right now, the only thing that the NGDG will show you is contested, uncontested. But that doesn't tell you anything because, there's so many cases like where there are quasi-judicial, almost administrative functions being carried out by judges. So for example, if I can give an example from the Drugs and Cosmetics Act, when pharma companies are prosecuted for manufacturing substandard drugs, there's a provision under the act where you can ask for an appeal to a central drug laboratory in Calcutta. And that's your statutory right. So when you file, you have to file that application only before the magistrate's court. And the judge doesn't have to do anything. There's no adjudication at all. He just has to pass an order saying, yes, I'm sending it out to, CDL. But all those cases also, all those applications again get logged as separate cases. So, I mean, these are all issues that, at least from what research we did, we haven't found, there hasn't been much work or thinking on this. And I'm hoping that the more people who write on this, there'll be some feedback for even the Supreme Court anytime they decide to rethink how the design of the e-court system. Now, the irony of all of this is that we used to have a superb system of judicial statistics under the British. So this is an excerpt of the Administration of Criminal Justice, which every high court used to publish for all the civil and criminal courts under it. So this is only criminal, but also actually the reports cover both civil and criminal. So chances are you will be able to do a better empirical project on 1891, 1879 Madras presidency than you can do on today's, the Madras state of Tamil Nadu on what the disposals are. And I've got a copy of the report in my bag. I'll just circulate it after I finish this meeting. Someone republishes it and sells it up at a very high markup, which we bought. But the quality of statistics is astounding. Like, all the data that you want is there. Including, how much money was collected for process fees. It's the most inane piece of information, but they collected and they logged it. And the reason that this used to happen was because the letters patent which the Crown used to issue to create new high courts, the last clause in all the letters patent used to be a requirement for the high courts to provide this information to government and to respond to further requests by government to develop, to fine-tune the kind of information collected. And today, that is not happening in India today. Let me just skip this one thing. So this is a Q&A in Parliament, a parliamentary question from 1985, where a question was raised in Parliament by Suresh Kalmadi and another MP, basically asking certain questions of the Supreme Court on how many judgments have been pending for how much time and the longest duration for which a judgment has been pending. And that's the response B and C, where the minister has responded, the Supreme Court registry have not furnished the information as discussion on this information is barred by Article 121 of the Constitution. Now, Article 121 of the Constitution doesn't say anything like this. Article 121 says that you cannot discuss the conduct of judges unless there is an impeachment motion being discussed. There is no bar against providing this kind of information to the, to Parliament. And as we narrate in the book, there's a post the RTI Act coming into effect. There is a long battle that Commodore Lokesh Batra fought with the Supreme Court over 7 years, asking for the same information. The Supreme Court lost before the Central Information Commission, the single judge of the Delhi High Court. They appealed against both, went to the division bench of the Delhi High Court, won over there. Commodore Batra files an SLP to the Supreme Court, one-line dismissal saying, we're not giving this information. I mean, so this is a very deep-rooted problem of judicial accountability. Like, this is an issue that you can't solve with just, better designing. I think some of this data actually you can scrape off the Supreme Court website and make it available publicly. But this is a problem that we're seeing with the courts when they deal with issues of judicial transparency. Like, we've written other stuff, not in this book, on just the court's approach to the RTI Act is astonishing. They have made RTI rules. So every public authority can make its own RTI rules. And the kind of RTI rules that some of the high courts have made would have been struck down as unconstitutional if they were drafted by any other public authority apart from the judicial. Like, that's the extent of unaccountability that we're talking about. I'm just going to finish with one last point. So The reform measure that we were suggesting in this regard was something like the Judicial Statistics Bill that was introduced by Fali Nariman in the Rajya Sabha when he was a nominated MP. So this came on the heels of a discussion in Parliament where Arun Jaitley and Kapil Sibal are both complaining that these judges are not giving us any information required even when questions are being raised in the House. So Fali Nariman had drafted this bill, which was quite good. So these are the data points that the bill sought to capture. And this was in the pre-digital age, so it was a much more clunky administrative mechanism. He wanted district-wise centers and all of that, which now technology will solve a lot of those problems. But I mean, he spotted exactly the kind of information that all of us would want to study the judicial system, including the number of hours being taken and adjournments granted, etc., etc. So I'll wrap up with that on judicial statistics. Oh, sorry, I have one more thing. I'll go through this quickly because I think it's a waste of time, but we have an entire chapter in the book on this. This is the elusive question of how many judges does India need? So the Supreme Court has been hearing this one case for 10 years. There have been 4 expert committee reports. It's very clear that chief justices are not reading these expert committee reports. This is basically on what is the methodology to calculate the number of judges that you require. So the popular story goes that we've not expanded the judiciary, etc., which is not true. So in 1987, we used to have 7,675 judges. Now we have 21,000 judges at the district level. I don't think any other arm of the Indian state has grown at this rate. Like it's tripled. I don't think even the IAS has grown at this particular rate. Plus, a fact that we often miss out is extrajudicial capacity has been created to divert a lot of work away from the district courts. So, like the Debt Recovery Tribunal took off a large chunk of work from the district courts. Then the National Company Law Tribunal, a lot of shareholder derivative suits used to go to district courts. That was transferred out, consumer courts, etc., etc. So, the debate now has been on how many judges does India need. And the Supreme Court has been stuck on this formula of we'll calculate judges as per population, per million population of the country. This is a methodology that has absolutely no academic basis anywhere. The Law Commission in 1987 borrowed it from Professor Mark Gallanter's affidavit in the Bhopal gas tragedy case, where Mark Gallanter was appearing as a witness for the Union of India to argue that Indian courts are too incompetent to decide this tragedy. Hence, American courts should assume jurisdiction. And probably Mark Gallanter did not have access to statistics, so he tried framing this as a measure. That is, per million people, you require these many judges. But a simple example that you use is just look at Delhi and Bihar, right? 10 times more population in Delhi, civil litigation rates appear to be more. So this is only cases instituted. This is not pending cases. So in 2023, Delhi had more civil cases filed than whole of Bihar, which has 100 million people. Criminal cases, Bihar is slightly more, but that's also because of their liquor prohibition law, which is really draconian. Everybody ends up in jail in Bihar. So the population litigation correlation is not completely established. There may be some correlation, but we suspect that economic activity, income levels will contribute a lot more because you need to be able to pay lawyers to litigate. So the Supreme Court has set up 4 committees. 3 of them have conclusively junked this population-based methodology. But every chief justice, when he becomes chief justice, says, oh, we don't have enough judges per million people. That's also because they don't make these reports available publicly. This entire nonsense is happening through the PIL process. So the last set of reports, there's a 5-volume set of reports authored by a retired Supreme Court judge for the NCMS, National Court Management System, which they're not making public. It was submitted to the Supreme Court in 2019. This was 2 years after the PIL had been retired. The old Chief Justice, he retired. Along with him, the new judges who came junked the PIL, forgetting that this report was pending. Now, that report they're not making public. They refuse to give it to us under the RTI Act also. But this is one of the silliest issues that takes up far too much time in the Indian debate on judicial reforms. Anyway, I'm done. Over to Chitrakshi.
Yeah, so this is really our explanation for what could explain the delays. If it is not short-staffed, it is not underfunded, then what are the institutional factors that are responsible for judicial delay and backlog at the level of the district judiciary? And our argument is really based on looking at the decisional independence of the district judiciary. Now, as per the constitutional framework, the high courts are supposed to administer the district judiciary in each state. They exercise the administrative control over the district judiciary. And this was drafted keeping in mind that these judges have to be protected from executive interference. So what they have really done is given high courts absolute control over the administration of the district judiciary. However, the manner in which this disciplinary control is exercised is, we argue, eroding the decisional independence of the judges at the level of the district judiciary, because decisional independence, which is the ability of a judge to take decisions freely, uninhibitedly, is really the core component of judicial independence. So you can insulate them from the executive and the legislature, but if they are still unfree to decide cases in a manner that they think fit, then this scenario is really problematic. Now, the first problem with this scenario is that the district judiciary is in fact subject to the same rules that apply to the civil bureaucracy of the state. The only difference is that in case of the civil public servants, it would be the state government exercising this control, and for district judges, it would be the judges of the High Court. And the High Courts, the disciplinary practices actually reveal that the manner in which they exercise it make it very difficult for the district judges to take free and independent decisions, and this is on the judicial side. So we have some examples. So of course, our argument is really, we are not arguing that judicial corruption and misconduct shouldn't be dealt with sternly, but we have found instances, and I'm saying instances because we did want to collect empirical data for this. We did file several RTI applications with the high courts, and only a few of us gave us that data. So for example, the Bombay High Court, which gave us those numbers, told us that between 2018 to 2023, it received more than 4,000 vigilance complaints against the judges of the judiciary in Maharashtra. However, it also told us that it chose to act only in 30 such cases and initiated inquiries in 30 such cases. And when we asked for the rules which give you that threshold as to why is it that you chose to inquire these 30 instances and not the others, they told us that we should not be privy to that information because this is internal communication between the High Court judges and its registry. So this is the first problem with this process, is it is entirely opaque. And we found several instances where, when the charge of corruption is not even proven on the basis of the judicial decisions that the judge has taken, which the High Court judges perceive to be incorrect, they have taken disciplinary action on those judges. So this is an example from a civil case where the judge Sadhna Chaudhary, she had just compensated a person in a land acquisition case, according to a judge, very generously. And that became the basis for disciplinary action against this judge in the absence of any finding of corruption or misconduct. So, of course, if they had evidence which would back those allegations, it would make sense. But there are many such instances where even in the absence of any evidence of corruption, they have been dismissed from service or removed from service. This is not restricted to civil cases. This is an instance where a judge who was prosecuting, was dealing with the prosecution in an NDPS case. They could not find any evidence of corruption, but since the judge had dismissed the case because the investigating officer had failed to appear before it more than 18 times, they decided to pursue disciplinary actions against the judge. And of course, all these definitions are very vague, and they would say something like, this shows that you don't have the adequate devotion to duty, you are unbecoming of a judicial officer. So these standards are all very vague and undefined. And this is, mind you, only the cases where we found that the charge was reproduced in the judgment, since that became our source of collecting this information. So there may be several cases where this charge is not even reproduced in the judgment, and we would not know the extent of the problem, given that they don't even release statistics on the administrative side. Judges have been, again, in a criminal instance, they have been punished for ignoring the mandatory minimum sentencing norms. Ideally, the issue of incorrect legal judgments should be taken care of on the appellate side. So there is no reason that an administrative disciplinary inquiry be initiated against a judge for what the supervising authority thinks is an incorrect legal decision. Another case where the judges thought that the bail was granted quite recklessly in a sexual assault case, and that became a cause for disciplinary action. Now, the second very serious problem with these inquiries is the standard of evidence that they rely on while taking these calls. So, you would find that in many cases, there will be no direct evidence for corruption, and the judges and we have found this information from judges who have been dismissed from service and have challenged their dismissal before the High Court. So the High Court would say that we know that there was no direct evidence, but it is very difficult to find direct evidence in such cases, and therefore we will presume that your action was illegally, it was extraneously motivated, and we choose to remove you from service. So those are it's based on hearsay. There is very little reliance on very concrete evidence standards that is relied upon in such cases, and this is a serious problem. Again, it's quite clear when they would say that, for example, the simple reason that in regard to an allegation of illegal gratification, finding procuring a direct evidence is a Herculean task, since beneficiary of a bribe will seldom come forward to depose without the tainted transaction. So those are the kinds of standards that are being relied upon to dismiss judges from service. And this really has to be seen in comparison to the protection that is granted to the upper judiciary, where you have barely 8 or 9 impeachment motions since independence, where they can only be, and the grounds for impeachment are also proven misbehavior and incapacity, where the standards are so different, and the hypocrisy of the High Court judges, which are administering the district judiciary under control, seemingly to protect them from executive interference. The second class of judges, which are also very insecure, and this is really basing the argument that security of tenure is a very important facet of judicial independence. This is the second class of judges which are also extremely insecure in their jobs, probationers and senior judges. So, as per the law, these judges don't really have a right to be heard when they are dismissed, because probationers are not really confirmed in service till up to 2 years. And in that period, when their performance is under almost daily review, they can be fired without being reasons given to them in writing. They don't have a right to be heard, and these summary dismissals are regularly upheld before the high courts when they challenge such decisions. The other class of judges which also face similar insecurity is very senior judges, because this is also an outcome of one of the All India Judges Association's cases, where they have a performance assessment mechanism when they reach some milestone ages such as 52, 55, 58, and they are subjected to a mandatory review. And on the basis of their ACRs and their records, if they are found to be unsatisfactory and if they have any adverse entries, anything can be made a basis to remove them from service. So these are very senior judges whose time would be better spent. They have that experience, and really, if they have not they have not been able to impress a particular high court judge, this could very easily happen to them. Also, lack of statistics becomes a serious problem, and this information we have gathered through newspaper reports, because whenever there are mass firing incidents, and that's how they are reported in the newspapers, some high courts will mass fire judges, compulsorily retire judges when they are the most senior and most probably capable of deciding cases. They mass fire judges. For example, you will find in the Gujarat High Court, they've fired approximately 12 to 20 judges together in a mass firing incident. And only then do they make it to the newspapers, given that we don't really have data released by the high courts as to how many such compulsorily retirement orders they pass. The second component of why these judges are really not deciding the more crucial and difficult and lengthy cases on time is the way that their performance is assessed. Now, they are subjected to an annual confidential review by the supervising judge, which contains several factors: their integrity, their relationship with the bar, their judicial performance, etc. Now, each high court has also devised a unit system, according to which they are given certain units. This is an example from the Calcutta High Court. So each high court has a unit system which, and what it does, it allocates certain number of units for each judicial task. Now, the criticism of this unit system is that they don't really take into account the complexity of a case properly. Now, for example, you could examine a witness in a day. The same examination could take very long if the case is very complicated. And so time and complexity of the case are not really factored into the way they have designated these units. The other problem really is that they have to meet these units. There could be a quarterly target, there could be an annual target. This is again from Bengal. And if they meet those targets, they will get the commensurate ratings. Now, it's quite clear that to meet these targets, the tendency of the judges is to make sure that they decide the easy cases so that they have the requisite targets to get the required rating that they want. And the lengthy and the more complicated cases are the ones that really fall off the queue. This has to be seen in combination with all the other policies. So this is one factor. The other factor, which is also incentivizing judges from not hearing the more tricky, the more difficult cases, is the transfer policies of the high courts. Now, there are mandatory transfers. And also this transfer policy, it is practiced at two levels. Not only are they transferred from one district to another. So, for example, in UP, every 2 years, a judge would be moved from one district to another. But even within that district, their portfolios are changed every few months. So this is the revolving docket, but they don't really have the responsibility to hear a particular case and complete a trial. And we think this, combined with the way the unit system has been devised, is really incentivizing these judges from hearing the more risky and the more complicated cases, because they do know that a successor, their caseload can be very easily transferred to the successor. The other problem with the transfers is that judges are really outsiders in this court ecosystem because they are not local. The bar is local, the court staff is local. And because they are continuously transferred, they are the ones who are outsiders in this system. And this has been argued by other scholars also, that this is one of the reasons why they actually cannot take control of the courtroom. So this is really disrupting their accountability mechanisms. And these policies also don't have a very clear articulation of what they are trying to achieve. So the policies will just give you that every 2 years the judge will be transferred. These are the grounds on which perhaps they will be given some consideration for them not being transferred. But there is really no articulation of what it is trying to achieve. Is it impartiality? Are they trying to restrain over familiarity with the bar? This is not really present in the policies. So I would just conclude our basic argument that is given in the first part of the book. So we want to move the narrative away from the resource crunch argument that the judiciary has been peddling. And our argument for explaining judicial delays is really based on 3 prongs. The first being the disciplinary framework that the judges are subjected to. The class of judges which are made specially insecure by the service conditions, which are probationers and the judges nearing retirement. The second prong is the very defective unit system which is used to assess the performance of judges. And the third prong being the transfer policies, where they are creating bad incentives and leading to a situation where the difficult cases are not really the ones that judges want to decide first. Okay, I can conclude. Thank you for your time.